Attorney Morgan Barroso on behalf of the people.
This case opens with the kind of tension that makes judges lean forward and prosecutors adjust their notes. We are dealing with People versus Dustin Hopkins, a 20-year-old defendant whose night spiraled into a series of police confrontations, multiple domestic violence allegations, and a physical clash with officers so chaotic that one ended up under the care of an orthopedic surgeon. That alone sets the stage. But once you hear how both sides describe the event, you'll realize this case is far from straightforward. On one side, prosecutors paint Hopkins as dangerous, unpredictable, and violent. Someone who not only shoved the victim but also resisted officers, punched two directly in the face, broke free from their grasp, and kept running until a taser was deployed and another officer allegedly drew their weapon. They argue he's lucky he's even out of custody. On the other side, the defense frames Hopkins as a scared young man with zero criminal history, panicking in a high-pressure situation and reacting instinctively rather than maliciously. They compare the event to a messy mutual conflict with the alleged DV victim, something far more complex than a one-sided attack. They emphasize no prior convictions, no prior police involvement, no missed court dates, and zero allegations of continued harassment.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Hopkins. Mr. Hopkins, would you state your name for the record, please?
Mr. Hopkins. All right, what are we doing?
Your Honor, we would ask for a preliminary examination. I would also like to address bond, and there are no offers at this time.
Right. Is discovery complete?
It is my understanding, yes.
And would the people have their witnesses available on the 6th?
Yes, Your Honor.
Preliminary examination will be set in person February 6, 2024, 9 a.m. That is before Judge Perry. As to bond.
Your Honor, we are just looking to address the condition of bond that requires that Mr. Hopkins be on house arrest. Prior to this matter, Mr. Hopkins was employed at FedEx as a result of having the tether plate. No longer able to, in this case, he was no longer able to maintain that employment. He is hoping to be able to get new employment and is asking that the court consider a no go-to order, a no contact order with the complainants, a no go to Eastern Michigan University, or anything of that nature. My client, Mr. Hopkins, also recently registered for the cybersecurity program at the University of Michigan. He did text me that information. I tried to send the confirmation to Ms. Barroso so that she would be able to see it. It's my understanding that the classes are majority online, but that would be the only place that he would have to come across Chenal County. Otherwise, he's just asking for some order that would allow him to work and just not have that kind of contact.
This is a classic bond modification argument. The defendant wants freedom to work and continue school. The defense tries to frame him as a young man trying to get life back on track. Employed at FedEx, recently enrolled in a cybersecurity program, showing initiative. Judges love to see structure, responsibility, and stability. It reduces risk. But here's where strategy kicks in. The defense emphasizes that his classes are mostly online. Why? Because they know the prosecutor will argue he doesn't need to be anywhere except home and court. The defense wants to show minimal movement, minimal risk, maximum compliance. But the real issue isn't his school schedule. It's the allegations we're about to hear from the prosecution. Because once the prosecutor takes over, this bond request hits a serious wall. Quick question for viewers. If someone is facing violent charges but shows good behavior after release, should judges loosen restrictions or keep them tight until trial?
Response.
Your Honor, the bond in this case was set at $5,000 cash or surety when we requested a $50,000 bond. In this case, the people are uncomfortable with him being out. This was an event for a series of events that occurred where the defendant assaulted the victim at not one but two locations. An eyewitness saw the defendant shove the victim while near the police station. The police attempted to make contact with the defendant, and then he picked up, as a result of him resisting, picked up 5 counts of R&O against 4 different officers. One of those 5 counts as an R&O causing injury that was so severe that the officer is actually seeking specialized medical treatment from an orthopedic surgeon. At this point, this is a 9.
So, hold on, there was a DV and then an officer injured. Why is he out?
Your Honor, if I could
Well,
address.
Hold on, I'll let Ms. Barosa finish and then you can address it. I just had an intermediate question. Go ahead.
So at this point, I don't think that a modification of bond removing him from being on house arrest is appropriate. We objected to a nominal bond of $5,000 when it was originally granted. At this point, I don't think that any further reduction is appropriate.
A couple of things. First of all, Mr. Hopkins is here with his father. He is 20 years old. He has no prior criminal history. In reviewing the police report and the video, even the report references that the altercation, that the incidents that resulted in this charge, that there were.
In which
that it was,
charge?
I'll start with the domestic violence. That with those charges, that there was a more complicated situation. I believe the officer said, the report says something to the effect of, and this would also go to the property.
The defense now tries to counter the prosecutor's narrative by reframing everything, not as an attack by Hopkins, but as a chaotic, emotional argument between 2 people. They point out mutual physical contact, broken objects, and a much more complicated dynamic than offender versus victim. The strategy here is clear. If they can weaken the DV allegations, then the remaining charges look more like panic, fear, or confusion, not violent intent. They also argue the officer's injury happened because the officer fell, not because Hopkins attacked. That distinction matters legally. One is a felony level, resisting causing injury. The other is an accidental consequence of a chase. They also highlight that he eventually stopped running, meaning he didn't flee indefinitely or attempt to escape the county. This is one of the strongest defense moments, and honestly, they present it well. But prosecutors are waiting with a bombshell. They claim Hopkins punched officers directly in the face. That contradiction is coming next, and it completely changes the tone.
That there had been physical altercations between the 2 of them, fighting between the 2 of them, and breaking of objects between the 2 of them. So I believe that there's more to this than said. The allegations of the domestic violence are the one of the shoving, and also I believe Mr. Hopkins taking his own computer back from the complainant. That's the second allegation of the domestic violence. And the resisting and obstructing is, the allegations are that Mr. Hopkins, not that Mr. Hopkins turned around and slammed someone or punched them or anything, that he pulled away. The allegation is the officer fell and that caused the injury. And then that officer fell, yes, as he pulled away. And then subsequently, 4 officers who were, some of whom just pulled up on the scene in the video, all ran after him. And that's where the resisting and obstructing comes. And he did, in fact, eventually stop. It was not, it's not as if he were in a vehicle and went miles or hours away. He did stop running, and he did, once they complied, once that occurred, there were no further incidents.
Your Honor, I'm sorry, that is not the characterization of the R&O. The allegations include him punching 2 officers in the face, breaking free of their grasp, causing them to fall to the ground, twisting and seriously injuring an officer's finger. And then it went on for such a period of time that an officer had to point and deploy a taser. And that another officer had to point their pistol at a defendant. So at the defendant. So at this point, I don't think it was him passively.
Your Honor, I had an opportunity to view the video.
This is the clash of narratives, and it's intense. The prosecutor says Hopkins did far more than run or pull away. They allege he punched officers, twisted an officer's finger, broke free from multiple grasps, and fought so long that a taser was deployed and another officer drew a firearm. That paints a picture of real danger, the kind judges do not ignore. The defense pushes back hard, arguing they saw no punches in the video. That creates a credibility conflict. Who is describing the event accurately? This matters because video evidence usually controls the narrative. Judges listen carefully when attorneys reference video because it can completely override written reports or testimony. When Judge Simpson asks direct yes-no questions, was a taser deployed, was a weapon drawn, he's signaling frustration. He wants clarity, not spin. And when the prosecutor confirms those details, the judge's concern skyrockets. Viewers, whose version do you believe so far? The prosecutor describing a violent fight or the defense describing a panicked young man?
Well, you had an opportunity to view the video.
Yes.
Let me ask you this. Was a taser deployed?
Your Honor, when the, and
I
as
think
soon,
that's either yes or no.
Your
Was
Honor,
was a taser deployed?
Your Honor, as soon as the officer saw him, she
Mr.
pointed the
Evans.
taser at him. This is not, as soon as she saw him, she pointed the taser at him. This is
So-
not a situation where he was running and pointed the taser.
I didn't ask
Make
that,
it
Ms.
cool.
Gaines. I did not ask that.
Yes, sir.
Was the taser deployed?
Yes, it was.
Did an officer have to draw their weapon?
I did not see that. I could not see that on the video.
Ms. Burrows, are you indicating an officer had to draw their weapon?
That is what was indicated to me in the file, Your Honor. Yes.
And then there's an officer that's injured. Again, we'll ask the question. I don't know why this individual's out.
Again, Your Honor, he's 20 years old. He has no prior history, and he has no reason to come back to Washtenaw County other than for school in this case. It's my understanding, I have not heard any information that he has had any contact with the complainant, has violated any orders. He is just asking to be able to go to work and to be able to get a job and go to work. Your Honor, would you want to hear from Mr. Hopkins' father, who's present?
I don't know what he could tell me at this point in time. I'm more worried about the bond as it originally is set. I don't, because what I have here and what's been indicated by the people is that he punched the officers in the face. Does he have prior convictions for anything?
No, Your Honor.
That the original domestic was about? I mean, I'm trying to figure out, because I'll just tell you, I have some serious concerns that this escalated to a point that officers are having to deploy a taser, pull their weapon, and there are clearly enough officers around to, in my opinion, have subdued this individual without having to do all of that. So something else is going on. And
Your Honor,
I also have, I mean, one's bad enough, but I have 2 counts of domestic violence.
again, Your Honor, one of them is him taking back his own computer. That's one of the allegations. And that's why I'm saying there were things that were happening before this. That's not to excuse his behavior. That is to say that there's broader context. And in my view of the video, initially there was 1 officer, then there were 2, and he managed to, and he ran from 2, but as he's running from those 2, there are cars, 4 and 5 cars are pulling up with sirens on an unarmed young man who clearly panicked. This is not someone who's had police involvement, who has a history of contact with law enforcement and the criminal justice system. Again, I'm not excusing, but I do think that there's more. I think there are more nuances to this than the prosecutor does.
Well, explain some of those then. Because I've got a victim of a DV that's injured.
Judge Simpson is openly frustrated, and for good reason. He hears two completely different versions of the same event, and neither attorney is giving him clean, consistent answers. Judges hate ambiguity in violent cases. The judge repeatedly asks, how did this escalate? Why were officers deploying tasers and drawing guns? The defense tries to isolate each allegation, no injury to the alleged DV victim, the computer taking allegation as one DV count, the officer injury being accidental, Hopkins panicking because multiple patrol cars swarmed in. But the judge's concern remains. When there are punches to officers, injuries, tasers, and guns drawn, even if disputed, bond modification becomes almost impossible. This is the moment the judge makes up his mind. You can hear it in his tone. He's not convinced lowering restrictions would protect the public or the officers involved.
She is not, the domestic violence person is not injured. It was the shove and the taking of there's no injury to her. Your Honor.
Domestic violence are 2 misdemeanor counts.
That is
The felonies here are 5 counts of are 5 counts.
Yeah, I see that.
Are no causing injury.
Maybe I misread that on the report, but
Yes.
the injury to the fingers, that's the officer.
That's correct.
Thank you. I don't understand this. I mean, there's a lot I don't understand. How, and I get there are resisting and obstructings that are filed that some may look at as questionable in terms of the charge. I get that. But I'm also trying to figure out how an officer gets injured, that there are punches to the face of officers. I mean, Ms. Gaines, I don't get it.
I understand what you're saying, and I'm saying I did not see any punches to the face when I observed the video.
Tell you what, I'm certainly not changing any conditions. Can you explain to me one reason why I shouldn't raise his bond?
Your Honor, he has appeared for every court date, and he has not picked up any new charges. He has not had any contact with the complainant on the domestic violence or any of the officers at Eastern Michigan University. My understanding from him is that he has only come to Washtenaw County for court. He does not even reside in this county. It does not appear he's a flight risk, nor that he is a danger to the community. He is here with his father. He has come to every court date, and he's highly responsive to my calls and texts. And absent the no offer in this matter, we'd be looking to resolve it.
Anything else from the people?
No, Your Honor.
You know what? I'm not changing his condition in the bond. I'm not at this juncture going to up his bond either, although of rights I should. Of rights, I don't think he should be out around tethered or not, given that behavior. But I'll let Judge Perry deal with that after she hears the preliminary examination. Bond will continue. Motion for bond reduction or changing condition is denied.
Thank you.
Judge Simpson ultimately refuses to modify bond, and he makes his reasoning clear. The contradictions between the prosecutor's and defense's version of events leave too much uncertainty. When the stakes include officer injury, alleged punches, taser deployment, and weapons drawn, judges almost always choose the safest option. Keep existing restrictions in place. In the bigger picture, this case highlights how dramatically perspectives can differ in high-pressure confrontations. Was Hopkins a violent aggressor escalating a scene, or a terrified 20-year-old overwhelmed by flashing lights, yelling officers, and a sudden police swarm? The preliminary exam before Judge Perry will reveal much more, especially once the video becomes central evidence. For now, the court prioritizes caution. Bond remains the same. No loosening, no reduction, no exceptions. If you found this case as shocking as we did, hit like, drop your thoughts in the comments, and subscribe for more courtroom breakdowns.